Well, greetings everybody. Welcome back. I'm excited to be teaching you today about war crimes. War crimes are a subject that are very interesting. They're one of the formal international crimes that are included within our concept of international criminal law, and I think exceptionally interesting. Let me give you a little overview of what we're going to discuss today. It is as follows. I really want you to understand the historical origins of the various categories of war crimes. In a moment, I'll show you the statute of the International Criminal Court, and you'll sort of see that there are different categories. It took me so long to figure out what I'm about to teach you today. I worked in the field for so many years and didn't quite understand why there were these categories, where they came from, what the significance of them was. And so I feel like what I'm teaching you now is a huge advantage. I suspect that lots of people who work in international criminal justice don't quite understand what we are about to go through. And it really, to my mind at least, is a very helpful orientation around what is some fairly confusing terminology and structure. So it's important, I think, for you to understand the historical origins of these various categories. I want you to understand the contextual elements of war crimes, including problems with them. And by contextual elements, I mean all of those things that are context elements that are required to prove war crimes. The most obvious of these is an armed conflict. It's really the distinctive contextual element of war crimes that they take place within an armed conflict, which is not a requisite element of crimes against humanity, war crimes, or, depending on how you view things, aggression either. So there are others also that we will go through together, and they will, I hope, inform your understanding about the scope and limitations of war crimes as international crimes. I also hope that you will come out of this lecture and our discussions after it with a broad understanding of the content of various war crimes. And by content, I mean, I want you to understand that pillage is a war crime. I want you to understand that feigning a flag of truce is a war crime. I want you to understand that torture is a war crime. Essentially, a broad overview of, well, what are war crimes and what's the scope of the criminality that is applicable specifically to wartime. And we'll go through a list and speak about that momentarily. And again, as is my focus throughout this course, I really want you to be able to situate these issues within the wider discussions from previous classes. It's important to me that in each of these instances, you are able to sort of draw connections and sort of understand my onion concept, how each new layer adds different ideas, and I hope greater sophistication to your understanding of the field. So we'll try and do some of that in our time together today also. So without further ado, what I thought I would do to start is actually just go through the ICC statute with you in a way to present a problem of understanding. And so let me just turn to that quickly now. So here is the Rome Statute of the International Criminal Court. Let me just scroll through it with you briefly. So as we go down, this is what it looks like. What I'm trying to do now is sort of give you an experience of what it is to sort of come to international criminal law and look at the constitutive documents and really not have much of an understanding of what it all means. And then I want to walk you through and give you an orientation which I think will make this more meaningful. So as you come down, part 1 is establishment of the court, part 2 is jurisdiction, admissibility and applicable law, and you come down here and you see Article 8. It exists within the context of other articles that talk about genocide, crimes against humanity, war crimes, and aggression. So that's where the sort of the crimes located. So we'll scroll down there. 6 is genocide, 7 is crimes against humanity. And then voila, 8 is war crimes. And I guess what I want to introduce you to is the idea that there are different categories of war crimes, and to sort of familiarize you with the different terminology, which I've criticized for a number of years as being overly archaic and deferential to a very old European concept of war. But nonetheless, I want you to become familiar with the terminology and what it means. So the other thing I want to pick up on is something that we sort of spoke about in a different context about international criminal law not being a monolithic single unity that's universal, that there's quite considerable variation within international criminal law. And so war crimes as defined in the ICC statute are not necessarily reflective of war crimes as defined in treaties, as defined in customary international law. And from the very beginning, you start to see this. So in Article 8.1, it says the court shall have jurisdiction in respect of war crimes, in particular when committed as part of a plan or policy or as part of a large-scale commission. And that highlighted language is new and specific only to the International Criminal Court. It's new and specific because technically a single war crime, you can kill one person or or torture one person or violate one of these norms, and it's a criminal offense. And so people in the drafting of the ICC statute or states were concerned about scale. They said, well, one, is that really going to be sufficient to trigger the jurisdiction of the court and involve the international court's sort of intervention if there's one war crime? And so the language that you see highlighted in subarticle 1 is an attempt to sort of massage this. And on the one hand, it's deferential to the groups of states who say, well, we only really want the ICC to intervene when there's like a long systemic policy of war crimes, not just one or two little incidents that would give it too much power. And then a competing group of states who say, well, no, technically a war crime is just a single act. A single offense. It's not like a crime against humanity that requires systematic offending. It's any individual event. And so this is this passage in yellow within the ICC statute is a beautiful reflection of how sometimes states agree on language that's more or less entirely vacuous in order to try and appease different sides to a political disagreement. And so especially the language in particular. And so the people said, well, in particular, sure. I mean, war crimes almost certainly apply where there's a plan or policy or large-scale commission, but in particular suggests not exclusively. And so people sort of made peace with this. But then the question became, well, is this language suggestive? What does it mean? What's the relationship with other aspects of international law that govern war crimes? At any rate, that's a slightly peripheral point. I want to start by showing you two. For the purposes of the statute, war crimes mean A. I'll get rid of my face here so that you can see the statute nicely. A. Grave breaches of the Geneva Conventions. And that's the first category. I'll go through this with you in just a moment on my PowerPoint. But the first category you need to understand is grave breaches of the Geneva Conventions of 1949. And it's crucial that you understand that these apply in international armed conflicts and only international armed conflicts. So what we will pick up on is our discussion from last time about in non-retroactivity about how there's really a sharp schism in international humanitarian law between the law that applies to international armed conflict and the law that applies to non-international armed conflict. To a significant extent, customary international laws merging those differences, but important differences remain nonetheless. And the history of war crimes and the 4 categories that I'm going to show you are largely divided along historical lines that reflect this division between international and non-international armed conflicts. So grave breaches regime comes from the Geneva Conventions. It's formally enshrined in a treaty, and it applies uniquely to international armed conflicts. And here are some of the provisions. I'll pick up on this in just a moment when I show you the PowerPoint, but I also want to suggest to you that up until the 1990s, war crimes were very broadly defined in such a way that really is largely inconsistent with strict interpretation of law. It gave to courts tremendous power of interpretation on the supposition, in fact, that legislatures would define these grave breaches with more precision in national legislation and enforce them through that process. But when that didn't happen, it was really left to an international court, especially the International Criminal Tribunal for the former Yugoslavia, to flesh out what each of these categories mean. So if you look at the first one, willful killing, well, war involves a lot of willful killing. So you're definitely going to want to circumscribe that, right? 3, willful causing great suffering. Well, what does that mean? Because, again, war involves the willful infliction of tremendous suffering. What is the circumscription and scope of that offense? Extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. So working backwards, wantonly is your first, I think, introduction to language within the war crimes provisions of both the ICC statute and elsewhere that is old, archaic, and I think very much deferential to European experiences of war. So what does wantonly mean, really? And have you ever had a conversation and used the term? No, you haven't, because no one speaks like that. Likewise, military necessity. Well, what does military necessity mean? And who gets to decide what's necessary in a war? How justiciable will these broad categories be? I really like 5 and find it really interesting and telling, compelling a prisoner of war or other protected person to serve in the forces of hostile power. It's hard for us to place ourselves back in the experience of the Second World War, where prisoners of war are forced to sort of load munitions onto airplanes that are going to bomb their own country. But it's such an intense experience that other courts describe it as torture, because effectively, in the context, you're inviting people to betray their country. In the context of a war, you're inviting them to be complicit in the death of their own nationals, which they have been fighting for. Many people preferred to be killed rather than do it. And so, in a way, 5 to me is interesting because I suspect that we've lost touch in some ways with the gravity of the offense in 5. And it speaks to a particular experience which dates to the Second World War most intensely. So it's interesting, the relationship between history and war crimes, and to some extent, there's always a criticism that war crimes are always codified to address the past war, and sometimes the past war becomes really quite dated relative to modern technology and lived experience. Willfully depriving a prisoner of war or other protected person of the rights of a fair and regular trial. Wow, that's an onerous obligation that in wartime you would give people fair trials, including people who have been shooting your fellow soldiers dead. So sometimes these war crimes provisions are onerous. Unlawful deportation is another grave breach, and that happens a great deal. But is a bombing campaign that produces a max exodus from a particular region a deportation, and what are the limitations? I wanted to give you, I guess, this beginning to introduce you to grave breaches as a category, to show you where they come from, to suggest that the prohibitions are relatively broad, and to give you a feel for what the content of that regime is. B in pink is other violations of the laws and customs applicable in international armed conflict. And I'll highlight where these come from in a moment. But the short answer to that is that, this is the category that Nuremberg invented. You remember how I told you how Nuremberg took violations of the Hague Regulations of 1907 that made absolutely no reference to criminal responsibility whatsoever. Nuremberg just sort of added that stuff, all of the criminal apparatus around them. These were known as serious violations of the laws and customs of war, and again, they are applicable to international armed conflict specifically. And I invite you to go look at the ICC statute and read through them carefully. What's interesting also is that if you look at the yellow highlighted piece here in 3, that the ICC statute has inserted new war crimes. So there was a degree of creativity involved in this process that was sort of breaking new ground. And that includes attacks on peacekeepers, which is an interesting phenomenon. Well, if you're in a war and peacekeepers attack you, can you shoot back? Interesting and complicated questions. Again, I've highlighted some of the yellow sections that I wanted to draw to your attention to highlight the breadth of some of these concepts. So in 4, it's intentionally launching an attack in the knowledge that such an attack will cause incidental loss of life, etc., etc. That is clearly excessive in relation to the concrete and direct overall military advantage anticipated. While litigating these sorts of standards proves fairly difficult because people have different assessments of what the concrete and direct overall military advantage is and what the incidental loss of life will be from an attack. And so some of these standards are broad and when placed within a sort of a criminal law framework are problematic to prove. VII 7 in yellow, making improper use of the flag of truce, is really interesting. These are the sorts of war crimes that are intended to protect the integrity of international humanitarian law. I remember once in a meeting of a group of prosecutors, they say, listen, some war crimes, they're really not that serious. It's like if you fake a surrender, saying, here's a white flag, we're surrendering, and then the other side, all right, well, let's go and arrest them and take them as prisoners of war. And you're like, psych, and pull out a gun and start shooting everyone. That's a serious war crime because it's not the shooting of everyone. Just faking the use of the flag is serious because once you start faking protected statuses like this, no one observes international humanitarian law anymore. It's like, they're trying to surrender? Nah, just kill them. They're not trustworthy. So interesting that there's this idea of, it's also known as perfidy. It's like faking a protected status. Religion, education, art, science, and charitable purposes are protected, but under conditions. XII 12 is one of my favorites because it reflects really, as I say, this old English concept of warfare and language that is deferential to that history rather than writing a new code which just sort of breaks down the categories and sets out wartime criminality in plain language, which was an option for the ICC, right? I mean, you know how I said earlier that it broke new ground in certain ways. It could also have said, you know what, these categories of war crimes, pretty confusing, language pretty archaic, probably alienating to at least half of the world, likely more because who reads this and understands its significance? I'll come to a practical example of this momentarily. So people could have looked at this stuff and said, let's just simplify and put it in plain language and strip out the old historical references, both to type of war crime and to particular concepts that no that no person has ever used in a plain language conversation for 100 years. And declaring that no quarter will be given would be a prime example of that. Well, what does it mean? Declaring no quarter will be given means telling your soldiers, take no prisoners. The famous Lawrence of Arabia scene where he's on his horse. No prisoners, no prisoners. The idea is, you know what? Even when people surrender, just shoot them dead. Surrender is not possible. Surrender is a fairly key concept in the attempt to humanize warfare. And so just telling your soldiers not to take any quarter is by itself a war crime, regardless of what takes place after that fact. But the language, well, who knows that? Who knows that? Which brings us to XVI 16, pillaging a town or place even when taken by assault. If you Google me and this phrase, you'll find something I wrote after I was in the Congo training war crimes prosecutors about the pillage of natural resources. And this again, I think, something I wrote criticizing the inclusion of this language in the ICC statute. So this language comes verbatim from the 1907 Hague Regulations governing warfare. And but there is another provision in the Hague Regulations of 1907, i.e. the same document, which says pillage is formally prohibited, which would have been way better to include here. Why this crazy deference to historical language? And it's especially confusing because academics say, oh, well, you know, you can't necessarily pillage natural resources in a war because that's not really a town or place. And like, was there really an assault? And is this confusing? At this sort of major conference in Kinshasa, these Congolese prosecutors are saying, well, you know, pillage of natural resources seems to be the core problem here for the last several hundred years. But if you look at the ICC statute, it refers to town or place, even when taken by assault. Pillage just means theft, right? And so there's this confusion. Well, you know, if you look into the history of it, this reference to a town or place, even when taken by assault, references the incremental prohibition of pillage. So initially, pillage was fully lawful in war, and it was a way of like incentivizing soldiers to participate. So, well, if you win the war, you get to pillage and like make a handsome profit for yourself and your family. So that was an incentive to join the war. What's pretty fascinating, though, about how it became prohibited is that armies found that if they allowed their soldiers to pillage in that way, they couldn't maintain military discipline. Like, soldiers would just do whatever they wanted. And so it was incrementally prohibited in European warfare. The first step to incrementally prohibiting it was to say, well, it's prohibited with the exception that when a town is so obstinate as to necessitate a siege, i.e. when a town says, all right, well, we're not going to let you just come in and take over. We're going to lock the city walls and keep you out. And so, you know, you're going to have to lay a siege, which is painfully boring. You're going to have to sit out there for 6 months and try and like starve us out. And, you know, you're going to have to wait patiently until we run out of provisions, and then you'll be able to take over. If a town is so obstinate as to do that, then you can pillage them once you take them over. But that was an exception. And then after a little while, they realized, oh, well, even that exception is ridiculous because it has the same problems and flaws. So we're going to prohibit pillage categorically. So to make sure that even the exception now is covered by the prohibition, we're going to write in the 1907 Hague Regulations this language that, well, pillaging is actually, it's prohibited even when taken by assault of an area, even when it has to be taken by assault or by siege. And so That the ICC statute in 1998, which is going about codifying wartime criminality, includes this language, is in my view, a spectacular failure to modernize the criminal provisions applicable to war, and immediately alienating to the vast majority of peoples of the world who are victims of pillage. I mean, it's amazing. Don't you think it's amazing? Think it through. Like, if you're really concerned about a particular set of conduct and you want to propagate the importance of that conduct broadly, and you want to be able to allow individuals, businesses, and so on and so forth to comport themselves in compliance with this, with these values, would you write a criminal code that is archaic and as confusing as the one that we are looking at? I suspect not. So let me keep going. Employing poisons, super interesting that that's criminalized. I mean, what's the difference between employing poison and employing like a grenade? Both are pretty damaging. We can talk more about that if you like. Bullets that expand or flatten, that's an historical reference to one weapon that was prohibited. XXII 22 is extremely important. It's the inclusion of a whole series of forms of gender violence in warfare that the war crimes had traditionally ignored. Notice that they are included as war crimes by reference to crimes against humanity, which again suggests the novelty vis-a-vis other iterations of war crimes. Again, if you're prepared to be novel, I think they should have gone further in being novel and consolidated some of these areas. In 25, starvation, and then 26, conscripting or enlisting children under the age of 15, which is also new and important. It relates to the discussion we had about retroactive criminal law in our last class also. So that, ladies and gentlemen, was category 2, and I'm going to summarize these in a PowerPoint in just a moment. But category 2 was, again in pink here, serious violations of the laws and customs applicable in international armed conflict. That was number 2. Then you get into number 3. In an armed conflict not of an international character, serious violations of Common Article 3 of the 4 conventions. We discussed this in the last section on non-retroactivity, how this one provision in the Geneva Conventions of 1949 purported to govern conflicts not of an international character. And what the Yugoslav Tribunal did in 1993 was highly novel, saying, oh, even though those provisions of Common Article 3 make no mention whatsoever of criminal responsibility. No mention whatsoever. Even though there's no mention whatsoever, and a stack of experts don't think there is criminal responsibility for violation of these terms, we're going to create it. We're going to construct it. And as I mentioned in the last lecture, states largely ran with that and included that idea within the ICC statute, which would have prospective effect. So this, ladies and gentlemen, cures that creativity because it's now features within a consent-based treaty that will apply prospectively. So here are the limited aspects of Common Article 3 in Category 3. And then finally, something that the ICC does that's important, that purports to reconcile the ICC statute with customary international law that has been growing. There's a big survey of the International Committee of the Red Cross that talks about customary international law and non-international armed conflicts. There's a whole new set of customs applicable in armed conflicts not of an international character. So again, more about civil wars or non-international armed conflicts. And here there's pillaging a town or place even when taken by assault, which quite how that got transposed from the Hague regulations that apply to international armed conflicts into the ICC statute is a mystery, but then how it gets parlayed into non-international armed conflicts also is twice beyond me. But you start to see that there is a similar content. There are differences though, like if you look at VII, so Roman 8, ordering the displacement of civilian population, well, that limits the deportation aspects of the grave breaches to just ordering. Declaring no quarter will be given, poison, and so on and so forth. So that's the structure of war crimes provisions. I hope going through the statute has been sort of helpful in orienting you. I'm going to switch now to a PowerPoint that just summarizes the categories so that you can sort of emerge with an understanding about the ways in which, when states came together to draft this provision, they were largely deferential to history and the ways in which pre-existing and parallel international humanitarian law governs these sorts of issues. And less interested in sort of like consolidating a clear and uniform code of wartime criminality. So let me come back here. And I'm just going to quickly summarize the different categories we just saw. The first is violations of laws of customs of war. Actually, my enumeration of this is not quite consistent with the ICC statute, because I think the ICC statute starts with grave breaches, which is my category too, but you'll get the picture. So violations of the laws and customs of war, which I think is the second category in the ICC statute, it's the first in the ICTY statutes, derived from 1907 Hague Regulations, which is a treaty that a number of states entered into. But notably, the vast majority of states in the world now didn't enter into that treaty because they weren't decolonized at that moment. It's significant for your understanding that that treaty makes no reference to criminal responsibility whatsoever. The sort of steps to criminalizing these aspects of the laws of customs of war were first the sort of the process in after the First World War that's talking about violations of laws and customs of war as a basis for criminal prosecution, which is then picked up by the Nuremberg Tribunal, which says crimes against international law are committed by men, not by abstract entities. And that's the process by which violations of laws and customs of war become one category of war crimes. The second category here, I think the first in the IC statute, is grave breaches. I want to highlight the two provisions, or there are several provisions in the 4 Geneva Conventions of 1949 that articulate a set of grave breaches, and there are additions to that set in Additional Protocol 1 of 1977 to the Geneva Conventions. But reflecting the breadth of some of this terminology, I wanted to highlight a couple of the provisions that govern grave breaches in the 4th Convention, and they look like this. The high contracting parties undertake to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed any of the grave breaches of the present convention, defined in the following way. Let me stay with that momentarily. The idea in the grave breaches regime was, let's leave it to states to go and promulgate their own national legislation governing war crimes, and we'll let them do it in their own way and however they see fit, i.e. a plural concept of war criminality. What the Geneva Conventions did not do, and had no intent to do, was to create a criminal law code that set things out in any detail, like the sorts of criminal law questions you need to answer, like, under what circumstances is a person responsible, what defenses apply, what are the precise definitions of each of these crimes. That was never the purpose of the Geneva Convention's reference to grave breaches. And so when you get to look at what the Geneva Conventions thought were grave breaches, again, of the 660 different provisions, only a small handful are designated as grave breaches, and they are designated that way because they seem like especially serious, hence the name grave. And this is what the provision in designating them looks like in Article 147. And it's worth reading it through. It's worth reading it through in part because this is the law that the Yugoslav Tribunal in 1993-94 inherited as the basis for its jurisdiction. And I want to invite you to think about our retroactivity class and the idea of strict interpretation in light of your imagined experience of being sort of a judge or a prosecutor in 1994 who inherits this body of law. It doesn't tell you very much about what any of this means. So it reads, grave breaches to which the preceding article relates shall be those involving the following acts. If committed against persons or property protected by the present convention, we'll say more about that. Willful killing, what does that mean? Torture, well, what's torture and what's not is an interesting problem. Biological experiments, willfully causing great suffering, we discussed. Unlawful deportation or transfer, we discussed. Compelling a person to protect and serve forces of the hostile power. Fair trial rights, taking hostages, extensive destruction and appropriation of property not justified by military necessity and carried it out unlawfully and wantonly. So you see where the ICC language comes from, but like, who knows what those things mean in 1993? So it's what a fascinating situation. So the next category is violations of Common Article 3, and we've discussed these in various ways, shapes, and forms in our class on retroactivity, and within this class also. The idea here is that despite nothing in Common Article 3 referencing criminal responsibility whatsoever, the Yugoslav Tribunal created a criminal law apparatus around the aspect of international humanitarian law in ways that largely mimic what the Nuremberg Tribunal did for war crimes or other categories of war crimes. Although the Nuremberg Tribunal openly said, listen, non-retroactivity is one principle to be weighed against others, whereas the ICTY reasoned as follows in the Tadic appeal decision. The intent of the Security Council, which they say was to cover war crimes and non-international armed conflicts, the logical and systematic interpretation of Article 3, in this instance it's referencing Article 3 of the ICTY statute that governs war crimes, as well as customary international law. The customary international law argument was a bit of a stretch. The appeals chamber concludes that under Article 3 of the ICTY statute, the International Tribunal has jurisdiction over the acts alleged in the indictment, regardless of whether they occurred within an internal or an international armed conflict. And so, again, it's asserting that, listen, even if it is a civil war, we have jurisdiction regardless. And then what took place in the fourth category that we saw in the ICC statute was there was a tendency to codify more aspects of international humanitarian law within the ICC statute. And so there was a sort of a transposition of criminality from international humanitarian law treaties, which the vast majority of which remains non-criminal in nature, and then its application in international criminal law, which has increased in non-international armed conflicts in this fourth category. That brings us then to the part where we discuss contextual elements. And I want to start with two and then elaborate a little on the first. So the first contextual element is one that I researched. Some of my very first research as an academic, close to 20 years ago, was on these issues. about the difference between international and non-international armed conflicts. And largely this research emerged out of a hesitation I had about how much energy was going into proving whether the conflict was international or non-international, and how to a large extent, the differentiation between the two was morally irrelevant as to whether targets should be held responsible for torturing people or not. I mean, it's morally irrelevant whether that torture took place in an international or non-international armed conflict. What we're discussing here really are vestiges of old historical categories in public international law that arguably aren't all that salient in terms of wartime criminality. Others might disagree with that. But the reality, nonetheless, from the ways in which war crimes are constructed, is you have to go about first figuring out whether the criminality took place in an armed conflict and then qualifying it either as international or non-international. It remains true that some international crimes have no equivalent in non-international armed conflict or differ slightly from one to the next. And so you have to be particular about which type of armed conflict you are charging. And that actually creates a tremendous practical burden on prosecutors who have to establish not just that there's an armed conflict, but this is the next of our issues, but that there's a nexus between the conflict and the crime. And the nexus is, it just means connection, is a test which is a little amorphous. I hope if you read through this section, you'll think, oh, well, it has to be shaped by, the crime has to be shaped by the conflict or influenced by it, but it's not it's not necessarily a counterfactual relationship. It seems a bit amorphous. The underlying idea is that during war, normal levels of criminality, theft, rape, assault, and so on and so forth, they not only continue in a society, they tend to go up. And they tend to go up merely because war creates a cover for ongoing criminality. I'm so aggrieved with my neighbor for picking the figs off the tree yesterday without my permission, and war gives me a pretext to go and burn his house down, which I've wanted to do for so long. It doesn't necessarily mean that me burning his house down is a war crime if it is completely unrelated and and non-contingent on the fact that there is an armed conflict 100 miles away in the center of the city. So the question becomes, well, how do we know when particular criminality is connected to the armed conflict? And there is a test here that I have on the screen that I won't read to you, which is an attempt to do that. I hope what you take away is that the test is relatively amorphous and vague, such that it gives judges a fair margin from which to determine whether a particular form of criminality is a war crime and can be prosecuted with an international criminal tribunal or court, or whether, on the other hand, it is some other type of offending and should be prosecuted by other institutions and courts elsewhere. I thought what I would do to flesh out this a little bit is to give you sort of a real world narrative about a conflict that has both international and non-international elements to it, which makes deciding whether the armed conflict is international or non-international relatively complex. And I'm doing this in part, again, to sort of nurture your critical faculties to think about whether war crimes in the ways that they define, say, in the ICC statute or prosecuted pursuant to customary international law elsewhere, which is highly deferential to these sort of historical categories that we've gone through, whether it might not have been better to sort of rationalize and strip away some of these contextual elements to make it a smoother, easier to prove set of norms. So let me move to this practical example. It involves a conflict in the Democratic Republic of Congo, which features as a fairly prominent aspect of the work that I do. It's a conflict that rage was more or less a continuation of the Rwandan genocide in 1994. And so I sort of developed a relatively keen interest in it because of that, and because of the ways that international criminal law interfaces with this particular region. So I'm going to give you a very brief overview of the conflicts in the Democratic Republic of Congo since 1996 till about 2015 perhaps, which is precisely a period when the International Criminal Court becomes involved and engaged, at least until after the year 2000. And what I'm trying to highlight for you now is the complexities of deciding whether particular violence takes place within an international or non-international armed conflict. And the reason I use the Congo in particular is that it's emblematic of a tendency in modern conflicts to internationalize very quickly. And so foreign states don't tend to just leave civil wars to run their course. They intervene, they support, they are cajoled to come to the assistance of different warring factions, which makes this distinction between international and non-international especially difficult. It was acutely difficult in the former Yugoslavia, and the same remains true of the Democratic Republic of Congo. I've written something on my blog about qualifying armed conflicts presently in Syria, which is also internationalized in important ways and extremely difficult. But I hope that what follows sort of reveals that for you in the context of the Congo. So in 1994, and I think I've referenced this in a previous lecture, the Hutu extremists who were responsible for the genocide were largely fled as the RPF entered into Rwanda from neighboring Uganda. And this created very substantial refugee camps, 2 million people at different places in the east of the Congo. And these refugees camps created tremendous insecurity in Rwanda and in the Congo, because many of the people within them would make violent incursions back into Rwanda. And so in 1996, there was a commonly known as a counter-genocide, where Rwandan forces entered into the Congo and killed several 100,000 people. There's a very interesting UN mapping report about this particular period, and it's an interesting period because it predates the jurisdiction of the International Criminal Court, and so there was some impetus to try and do something meaningful about it, given the extent of the spectacular extent of the violence. But up until now, there has been no accountability for what was really a spectacular set of atrocities. In 1998, Rwanda assists Joseph Kabila to march the breadth of the country and overthrow Mobutu Sese Seko as president of the country. And soon after that, though, Kabila rejects Rwandan and Ugandan support that brought him in, and so begins a tremendous war, in large part financed by resources, and then balloons into what Madeleine Albright called Africa's First World War, where up to 11 countries have troops fighting in the Democratic Republic of Congo. The government, on the one hand, would remunerate other governments for coming to its assistance by saying, well, you can have access to this diamond field. And Uganda and Rwanda created substantial zones of control through Congolese proxies called, in purple, the RCD Goma, which is a Congolese rebel group, which was widely viewed as the proxy for the Rwandan government. And the green zone was the MLC, the Mouvement pour la Libération du Congo, and that was widely perceived as controlled by Uganda. And natural resource exploitation takes place in all of these contexts, but there are complicated relationships between the foreign governments like Libya and Zimbabwe and Angola and Uganda to Tanzania with troops in the Congo, and between the rebel groups, which in some levels appear independent and on others don't. And so what you start to get is that a very complex process of deciding where, say, violence in areas that might overlap between control or violence at the peripheries of areas of control, which are the rebel groups that are involved, what's their relationship with foreign governments, how does the fighting relate to Kinshasa's invitation for foreign governments to be acting as their proxies. It becomes complicated. And as a result, the International Criminal Court in adjudicating cases has reached diametrically opposite positions about whether some fighting in particular regions could be characterized as an international armed conflict, and in other instances where it can be characterized as non-international armed conflict. If you're interested in these cases and the sort of the flip-flop between them, I encourage you to Google my piece on my blog, which I think is entitled, "How Would War Crimes Prosecutors Qualify the Armed Conflict in Syria?" So, final contextual elements that I want you to think about are the protected status. So the protected status of an individual or property varies from one regime of war crimes to the next. But if we think about Common Article 3, the protected status then is a person whose hors de combat is the touchstone. And that means a person who's taking no active part in hostilities, including members of armed forces who have laid down their arms and those placed hors de combat by sickness, wounds, detention, and so on and so forth. So the protected person needs to be protected within the category that you're describing, which means in the case of Common Article 3 that it can cover crimes against soldiers if they're surrendering, for instance, and they're still killed. The final element that I wanted to establish for you is that you would then now have to go to the specific elements of each war crime in addition. So if deportation is involved, you would have to have the expulsion of individuals across a border. If declaration of no quarter is the war crime involved, then you would have to have a public announcement of some sort saying that prisoners won't be detained and that one should massacre them all. These elements, and this is really a helpful development in the ICC context, is that when states found out that, well, by its nature, the International Criminal Court would have jurisdiction over themselves, they made a move to concretize and make explicit what these broad categories of war crimes would mean in an attempt to minimize judicial scope for judicial creativity. And so they did this by creating a document called the ICC Elements of Crimes, which attempt for the first time to make the ICC statute something of a criminal code that really identifies the requisite norms that must be proved in order to satisfy a conviction for each of these war crimes. And if you're interested in war crimes, I suggest you take a closer look at that document. It also has elements for crimes against humanity, genocide, and aggression, which I think will be useful to your understanding if you want to be very specific about what each of these offenses means. So that then is the overview of war crimes. As I say, it took me so long to figure out the origins of each of these categories, but I hope that the sort of terrain that we've covered gives you insight into where each of these categories comes from. I hope it helps you think about the role of international criminal justice and think critically about whether war crimes could have been better defined in ways that deferred less to the history through which these categories developed and more towards sort of a plain language text that propagated and diffused norms in such a way that they increased the likelihood of these norms being complied with in practice. But nonetheless, I hope what emerges is both an understanding of the contours of the field, the strengths of it, the difficulties of proving it, and a critical perspective on how it might have been different. Wonderful. Thanks so much. I'm looking forward to the conversation now.